Welcome to this series of videos about the Iowa Guardianship and Conservatorship System for Adults. It was developed by the Institute on Guardianship and Conservatorship at the University of Iowa College of Law. This third video in the series will give you basic information about establishing conservatorships for adults. Please be aware that conservatorships must be created and conducted in accordance with Iowa law. The information in this video is for your education only. It is not legal advice or a substitute for legal advice. You should consult an Iowa lawyer for legal advice if you have questions about a specific conservatorship case. What is a conservatorship? A conservatorship for an adult is a legal arrangement the court establishes by appointing one person, called the conservator, to make decisions for another person, called the protected person. The conservator makes decisions about the management of the finances and assets of the protected person. Examples of such assets are bank accounts, real estate, and personal property. When can the court establish a conservatorship for an adult? Iowa law spells out the requirements to establish a conservatorship for a person who is an adult. First, the court must decide that the person's decision-making capacity is so impaired that the person is unable to make, communicate, or carry out important decisions concerning their financial affairs. Second, the court must decide that appointment of a conservator is in the best interest of the person. The court must base these decisions on clear and convincing evidence. In other words, the court must decide that a person cannot manage their finances and assets and needs the help of a conservator in making decisions because of impaired decision-making ability. Various types of disabilities or illness may impair a person's ability to make decisions, leading to the court's appointment of a conservator. They include, but are not limited to, intellectual disabilities, Alzheimer's and other types of dementias, mental illnesses, and traumatic brain injuries. A conservatorship significantly restricts the protected person's independence and freedom. When the court appoints a conservator, the protected person no longer has the legal authority to make decisions about management of their finances and assets. The conservator makes these decisions for the protected person unless limited by the court. In some cases, however, there may be help and support available that would meet the person's needs but would be less restrictive than a conservatorship would be. If there is a less restrictive alternative, a conservatorship should not be established. To establish a conservatorship for an adult, a document called a petition requesting the establishment of a conservatorship must be filed with the court. Any person concerned about the welfare of an adult may file a conservatorship petition. The person who files the petition is called the petitioner. The person for whom a conservator is requested is called the respondent. This flowchart shows the steps in the process for establishing a conservatorship and appointing a conservator. During this process, the respondent has a right to have a lawyer appointed by the court. The court also may appoint a person, called a court visitor, to gather information for the court to help the court in making decisions about establishing a conservatorship. There must be a hearing where evidence is presented about whether the requirements for establishing a conservatorship have been met. The respondent has a right to be present at the hearing. Iowa law does not set out specific qualifications for a person to be appointed as a conservator for an adult. Iowa law just provides that the court may appoint any qualified and suitable person. Although many conservators are family members of protected persons, banks and other financial institutions also serve as conservators. Iowa law requires a background check of a proposed conservator, including checks of criminal records and the child abuse, dependent adult, and sexual offender registries. The court must consider this background check in deciding whether to appoint a proposed conservator. To serve as a conservator, a person must obtain a surety bond. This is an agreement between the conservator and a surety company meant to ensure that the protected person receives compensation for financial losses if the conservator misuses the conservatorship assets. The conservator may use conservatorship assets to buy a bond from a surety company. The court may exempt a conservator from the bond requirement if there is an alternative that provides sufficient protection to the conservatorship assets. There also is an exemption when a financial institution serves as a conservator. After the hearing, if the court decides to establish a conservatorship, the court will issue an order granting the petition for conservatorship and appointing a conservator. The clerk of the court then will issue a legal document called the Letters of Appointment showing that a conservatorship has been established and naming the person appointed as conservator. Providing copies of the letters of appointment to people proves to them that the conservator has legal authority to act for the protected person. After appointment, the conservator has to find and take control of any income the protected person receives or is entitled to receive and any assets of the protected person. For example, a conservator should establish in a separate bank account in the name of the conservatorship for the protected person's money. In order to find and take control of the protected person's income and assets, the conservator must notify and present copies of the letters of appointment to whomever has a financial relationship with the protected person. This may include banks or other financial institutions, insurance companies and agents, retirement and pension plans, stockbrokers and investment companies, and government agencies from which the protected person is entitled to receive benefits, and the protected person's debtors and creditors. Once you are appointed a conservator, you have very important legal and ethical responsibilities to the protected person and to the court. If you are a conservator, you must manage the protected person's assets and finances only for the protected person's benefits and not for your own benefit. You must avoid conflicts of interest and self-dealing. If you are a conservator, you must keep the protected person's assets separately from your assets or those of others. You must not commingle the protected person's assets with yours or those of others. If you're a conservator, you must manage the protected person's investments and other assets carefully and prudently. If you are a conservator, you should make reasonable efforts to consider the protected person's current and previously stated wishes and preferences, and to maximize the protected person's independence and self-reliance. If you are a conservator, you must keep accurate and complete records regarding the protected person's assets and finances. If you are a conservator, you must make periodic reports to the courts about the protected person's assets and finances and your management of them. This concludes this video about establishing conservatorships for adults. We hope you have found it helpful. The next video will give you an overview of court monitoring of conservatorships and the reporting requirements and powers of conservators. We encourage you to visit the website of the People's Law Library of Iowa for more detailed information and resources on this topic and other topics related to conservatorships.